Move the slides for everybody. So that is some of our contact information there. Along the bottom, a little harder to see. The last slide in the slide deck will also have our contact information if there are additional questions. So here's just an outline of what we wanted to try to cover in general about the PPP loan program. So we wanted to just provide you with an understanding in general of the program. And why is that important? Well, I know that we want to focus on the forgiveness of the loan amounts. But it's important because while there's a lot of information out there, there are still a lot of questions that are not particularly well addressed or may not be addressed at all in the materials that have been released. And in our view, the best you can do is to try to figure out what the answers are based on the context of the program, what it was trying to achieve. So we'll delve into that a little bit. We're also going to be talking about how to determine the loan forgiveness amount, specifically what parameters there are, what goes into that, what doesn't go into that, and how you can try to calculate as best you can what portion of whatever PPP loan proceeds you received is subject to being forgiven. One important point there that I know Helen will talk about in more detail is the distinction between permitted uses of the PPP loan proceeds versus what's forgivable. So without going into too much detail here, you should just generally be aware that when you receive the PPP loan, there are ways you can use those proceeds that are permitted under the loan program, but not all permitted uses are necessarily subject to being forgiven. So the forgivable use of the proceeds is a subset of the proceeds, and you just need to keep that in mind. So also in talking about the loan forgiveness amount, you've got to, again, think about what the goal was, so the goal really was in part to maintain staff, maintain headcount, maintain payroll. Those are kind of the primary purposes of the program. So when you're trying to figure out what you think should be forgiven, you got to keep that in mind as a kind of a driving consideration. We also want to talk a little bit about reviewing the forgiveness application process. So obviously you need to be aware of what that process looks like, how to apply, when to apply, where you apply, and just what that process will look like when you get there. And finally, we just want to talk about some tips that we've got to try to maximize the loan forgiveness that you might be able to obtain. So we want you to try to avoid problems and be ready to apply when the opportunity arises. So we also, of course, as lawyers, have to provide you with a legal disclaimer. So we're getting together today and want to provide everybody with some general information about PPP loan forgiveness. We're not intending to provide anybody with legal advice, whether you happen to be a client or not, but we do want to try to answer your questions as best we can. But just want everybody to be aware that everybody's circumstances are slightly different. And if you do have very specific questions or are looking for advice that you can rely on, you just need to speak to your own advisors. So again, when looking at the PPP and trying to consider what the context is, you've really got to, you can even go back and look at the name of the act itself and the program, right, in terms of determining what the goals were. So the Keeping America Workers Paid and Employed Act, that's Title I of the CARES Act, really does nail down that the primary goal was to provide funding for companies, recipients of the loans, to keep the people working, keep them off of the unemployment rolls, to keep people engaged, and to try to dampen the economic impact on individuals and small businesses due to the COVID-19 pandemic. And the Paycheck Protection Program, PPP, also encapsulates that same concept, which is trying to protect the ability of employees of small businesses to continue to earn a living, even while the businesses that they work for perhaps had a significant slowdown in the amount of work that they had. This was a way to allow companies to keep people fully paid, even if not fully engaged in the business. So contextually, I think that that's just a helpful perspective to have when you're looking at the goals of the program. the stated goals of the program were really the three things you can see on the slide, right? It was they would generally wanted to provide that economic relief. It was well understood that as the restrictions on gathering and coming to the workplace and a whole bunch of other things were coming into full swing, that small businesses were going to suffer significant economic challenges. So the goal was to provide money and resources for companies like yours and others. One of the problems, though, when the money came in, it came in because it was rolled out so quickly with a significant amount of uncertainty. And that's one of the reasons we're here today, is to try to work through as best we can some of the uncertainty and perhaps give you some tools to try to navigate the questions that will come up undoubtedly as you're trying to figure out and nail down exactly how much of the loan proceeds you received are forgivable. The second, goal of the program was to provide that relief to small businesses. We'll talk a little bit more about that in just a minute. But the focus was intended to be on the smaller businesses rather than the larger businesses in the economy, anticipating that it was going to be the smaller mom and pop operations or maybe larger small businesses that were going to suffer mostly from the impacts of the social distancing and all of the other rules that have been imposed in connection with COVID-19. And that was one of the reasons that the loan program was rolled out through the SBA. The SBA was considered a tool that was already a familiar funder for small businesses, had at least some of the infrastructure set up, although its infrastructure, as you probably are aware, was overwhelmed in a variety of ways and at a variety of different times, trying to keep up with the flood of the applications as they came in and the amount of money that had to go out the door. And that really was, one of the third goals of the program, was to try to get this done quickly. So while it was done relatively quickly based on the amount of money that went out the door, there was always, it had to be done in two stages, as you're probably aware. The initial amount of the program was $349 billion. That was swallowed up within the course of a couple of weeks. There were 1.7 million loans that were made with the first amount of the PPP money. Average loan amount was about $200,000. There was a second slug of PPP loan proceeds that some of you may have been able to take advantage of. That was $310 billion. So it's, $660 billion of money was made available for this program, which is an enormous amount of money and far, far exceeds the amount that the SBA has lended out in the past in any kind of reasonable period of time. So, that was the goal of the program: provide economic relief, get it out quickly to small businesses. Now, with all of that, one of the things that you're aware of as a small business is trying to make sure that you have the ability to plan. And one of the problems that's come up that we'll talk about as we go through our comments here is the uncertainty that comes with kind of confusing, maybe inconsistent, maybe lacking guidance from the SBA and other agencies. The Treasury is another one. And one example of that is with these kind of shifting regulatory standards was just in the application itself. In the application, as you may be aware, you had to certify that as a recipient of the loan or an applicant of the loan, that the current economic uncertainty made the loan request necessary to support the ongoing operations of the applicant. To me, seems like a pretty low bar. You didn't have to certify anything greater than that in terms of need. You didn't have to document a particular need. And initially, it really opened the floodgates to just an inordinate number of applications from a variety of different types of businesses for these loans. And then the SBA shifted the ground rules, right? And in an update that came out recently, they've done a couple of things. Number one is they changed the rules to say, well, wait a minute, if you're a larger company that has an alternative access to capital, even if you think that under the current economic conditions, you think the loan request was necessary, because you had an alternative place to go for capital, you shouldn't have applied for this loan. That was nowhere in the initial loan application, the initial guidance, or anything else. It was something that came up later as they tried to plug a hole, realizing that companies that were really not intended to benefit from the loan program were actually able to go out and obtain one of these PPP loans. So they've shifted the rules. They also shifted the rules in talking about this certification, and have decided that any recipient who has received less than $2 million is subject to a safe harbor. And the assumption will be that any applicant that received less than $2 million made the certification statement about the uncertainty and the loan necessity. They made that certification in good faith. So you're in a safe harbor if you received under $2 million, and won't be subject to audit on that question unless there's some clear evidence that for whatever reason you weren't actually in need of the loan. So with that, and keep in mind too that the regulatory sands continue to shift. I understand that the SBA has regularly released guidance, as has the Treasury Department. On average, there's been basically one release a day, some days with more than one release and some days with less. Some of those releases relate to forgiveness, not all, but it just gives you some idea, as we talk in more depth here in a minute about the forgiveness, what kind of regulatory environment we're trying to deal with. And I think it underscores the need for an understanding of the basic context of the loan program, what it is they're trying to achieve, and how the use of the proceeds may be viewed in the context of loan forgiveness. And the guidance that's come out so far has, in some cases, been contradictory, which can be very hard for planning purposes, is sometimes not supported by the language in the CARES Act. I just give one example of that with regard to the certification about necessity, and then the later release that kind of turned that on its head a little bit, at least if you were a bigger company. And some of the guidance that comes out is intended to be retroactive. Again, going back to that same example, they say, hey, look, at the time you applied, this was not one of the rules and one of the considerations, but it is now. And they actually extended until today an opportunity for companies to repay the full PPP loan if they think maybe they didn't actually need it and applied for it anyway.
That date got extended to May 18th from the 14th yesterday.
Further extended, okay, to the May 18th. So if you do have a PPP loan, and you decided that it's not absolutely necessary, or you have alternative capital resources that you can delve into through your business, one of the things before you even get into forgiveness you may want to think about is whether or not that loan should be repaid. So I think they've now decided that the floodgates open too quickly, and now feel as though they're trying to pull back a little bit. So what does all of this mean, for forgiveness? Again, with the context of trying to help small businesses, economic uncertainty, keep people paid, it just provides a framework to look through as we will dive into momentarily some of the more specific rules around the PPP and loan forgiveness. And our view is you just need to tread carefully, tread lightly. And in doing that, you need to do a few things. You need to keep very detailed records. We'll talk a little bit more about the detailed records and the documentation that we think in those strategies. I'll come back actually after Helen's comments and address some of those things. We would also suggest that you consider for forgiveness only those expenses that are explicitly permitted. So I know there were a couple of questions about raises, questions about bonuses. Neither of those is specifically addressed in the guidance that we've seen so far. And there's actually two different ways to look at it. Number one is, well, it just says that we're trying to protect paychecks and the salaries that people make. Can we pay a bonus? I think if it's a regular bonus that you would normally have otherwise provided, within the timeline that you happen to be making a distribution out of your PPP funds, that's a stronger case than if you've decided you want to prepay, for example, holiday bonuses, right? Because you've got the money. So, you generally, I think, want to continue to operate in the way that you normally would. You're obviously not precluded from making those bonus payments. You can certainly make those bonus payments. You can certainly provide people with raises. The question is whether or not those ultimately will be forgivable. My guess is that there will be further guidance around this that will come out in the next couple of weeks, because it has been a pretty common issue that actually we've been talking about quite a bit at our firm and with other clients, because it's not explicitly detailed in the guidance so far. So certainly it could be paid. I think if it's in the regular course of your business, you're not trying to accelerate a payment that might become due later, it's within reason, then those are things I think that you have a good case for asking to be forgiven. To the extent they're out of the ordinary, or to the extent you're making payments because you feel as though you have the funds, to the extent you're prepaying something that might be due later, I think those are all problematic. Another example, I guess, would be rent, right? As Helen will talk about in a minute, you have an 8-week period to utilize your PPP loan proceeds if you want to consider those proceed usage forgivable. So can you prepay rent? Our view is probably not, at least not safely. And Helen will talk a little bit more about the parameters around that. So why don't I turn it over to Helen? She'll have control over the slides here, and she's going to dive into more detail around some of these questions.
So great. So just turning back first to what we were just talking about, one of the reasons that acting in good faith and paying attention to what you're certifying and how you're using these funds is particularly important for defense contractors is the False Claims Act. So you want to, particularly for federal contractors, have a particular incentive to be more conservative and to pay closer attention to what and how they're using the funds than perhaps an ordinary business where they wouldn't be subject to losing the ability to enter into contracts with the federal government. So turning now to forgiveness, the very first question is, what are even the allowed funds under the Paycheck Protection Program? And there is a slightly wider set of expenses that are permittable uses of the proceeds that might not be forgivable. And this is important because there are just distinctions between what's ultimately what's permitted and then what's forgivable. So, and you don't want to spend any of these funds on things that are not permitted. That, separate and aside from forgiveness, there are serious penalties vis-a-vis the federal government for using these funds in an impermissible fashion. So generally, there is a new requirement that for all loan expenses, whether or not you're looking for forgiveness or not, 75% of the loan amount must be used for payroll costs. And payroll costs are a specifically defined term. We don't have time here to get into all of the details, but it is limited to $100,000 annualized for an employee. So for payroll costs, you're talking about $15,385 per person is the maximum amount. So when you talk about bonuses and the like, that's all subject to this cap of what is permissible. And there are, beyond the payroll costs, you can use the funds subject to the 75% limit on the payroll costs, also for employee compensation over and above the payroll costs. For mortgage interest, rent, utilities, there are specific requirements that those payments be made on obligations that were incurred prior to what they call the covered period, which starts on February 15th. So the most important point here is on the permissible expenses is that the requirement of spending 75% of that money on payroll costs applies to not just forgiveness, but to the permitted expenses. Once you've gotten past the hurdle of have you spent the money on the loan proceeds in a permissible fashion, you can then turn to the question of have I spent those funds in a manner that is forgivable? And forgivable expenses, again, they turn the test on its head, but only 25% of the ultimate amount that gets forgiven can be for non-payroll costs. This is a distinct test from the permitted expense test of 75% for payroll costs. On the forgivable expense, the maximum that can be forgiven on non-payroll costs is 25%. So that 25% can be spent on mortgage interest, rents, and utilities. But there's this real focus on this 75% effectively on the payroll and group benefit costs and the like. And that has led to some real problems for employers because the loan amount is equal to 2.5 times the historic payroll number. So your employers are receiving above 100% of their payroll costs. And for many employers, their payroll costs are now lower than their historic numbers because of layoffs, people being out on sick leave, people preferring to be on unemployment given the $600 pandemic extra benefit. And that has really led to a lot of questions for people, which is what is driving this question about bonuses. Because the employers are trying to get money to employees to satisfy the 75% payroll requirement. And again, as we were just talking about, we want to try to do things in the normal course, in an ordinary cadence for your business, even though these are very not normal times. And so that's a big question, and there's just not a lot of guidance. So you really have to look to as Matt has been reiterating, look to the purpose of the act, do things in good faith, do things that if you were the one business from New Hampshire that got called to Congress to testify about how you used your funds, that you'd be comfortable on national TV explaining what you did, not doing anything, sort of that you wouldn't be comfortable with.
So Helen, a question just popped up about whether allowable bonuses in the regular course of business during the forgiveness period for employees earning $100,000 or more, would those be forgivable? My quick answer is no, but why don't you chime in?
So yes, so there's the forgivable expenses are limited to a maximum on the payroll costs of $15,000 and $385 for the payroll costs. So a bonus that takes someone over that maximum payroll number is not forgivable. And the health benefits are basically group health benefits. So the other requirements for forgivable expenses is that they have to be spent within this 8-week period. The 8-week period starts on the day that your loan is funded. And there is language, and it's unclear to people, especially on these prepayment issues, what the Payroll Act, the Paycheck Protection Program says that the forgivable expenses must be for costs incurred and payments made in the 8-week period. And does that mean that the cost has to both be incurred and the payment made in the 8-week period? The and would seem to suggest that. There's another reading that the way the act reads is it talks about payroll costs and it talks about payments for rent, payments for your mortgage, payments for interest, such that it's payroll costs that are incurred in the 8-week period and then actual other payments made during that 8-week period. So, and the further thinking is that you can catch up on, you might be able to catch up for rent payments, other payments that you make during the 8-week period that extend to a period prior to receiving your loan, and make them during this period. That might be allowed, that's not clear, but almost everyone agrees that you cannot prepay. They make it very clear you cannot prepay your mortgage interest, but that as a general matter, prepayments are not going to be allowed. But there's really no clarity on this, and people are just doing their best trying to figure out how to deal with this. So the company-sponsored life insurance, I do not believe would be included, and the 401k match retirement benefits are included in the ordinary course. If you were to make a special 401k match during this period, that's not clear whether anything out of the ordinary course would be covered. So once you've spent 75% of your money, of the whole loan, on payroll costs, once you've spent no more than 25% of your, you're looking at your payroll costs and your non-payroll costs that are forgiveness, or that are subject or eligible for forgiveness, there's another possibility of further reduction. And there's a reduction on a percentage basis if you have fewer full-time equivalents during the 8-week period than you did in the comparison period. And there's some ability to choose different comparison periods, either the beginning of the year or a period from last year, but you have to compare these full-time equivalents. It's unclear how exactly full-time equivalent employees are calculated. There has been some additional guidance released that makes it clear that if you make an offer of an employment to a laid-off worker and they do not return, and you document both the offer and there are qualifications on what that offer has to look like, being comparable to what they used to make. But if you recall a worker and they don't come back and you can document that, there is now a new provision that you will not be subject to this headcount reduction for that particular worker. There's also a reduction to the forgiveness amount on a dollar-for-dollar basis if any employee's compensation is reduced more than 25%. There are some questions here because the comparison period is to the last full quarter in which that employee was paid, and a quarter is 12.9 weeks, and this is an 8-week period. So every employee, if they made exactly the same, would have a 38% reduction in compensation, and no one really thinks that's what was intended here. So it's presumably the overall an apples to apples comparison. So take an 8-week average from the prior quarter, how much they made during this 8-week period. But again, that's not clear. There's a lot of questions about how that's going to work. And there is a further provision, sort of a safe harbor, that if the full-time equivalent employee decrease is quote unquote eliminated by June 30 for reductions in headcount that occurred between February 15 and April 26, that the headcount adjustment won't be made. And there's a similar safe harbor if the compensation reduction is quote unquote eliminated by June 30. There's very, very little clarity about how those exemptions are going to be actually calculated. And so there is that prospect out there, but we really don't know what exactly that's going to look like, what it means to have eliminated the reduction and to have eliminated the compensation. So there's a lot of questions here. And again, the best advice we can offer is to be reasonable and to try to operate and make decisions as if you have to pay this money back and spend the money in that fashion, because it's very unclear right now how this is going to be treated.
One last thing, Helen, on those expenses. A question has come up about employer-provided disability and life insurance. So I know that as I read the guidance, it does say that payment, so as a payroll cost, payment for the provision of employee benefits consisting of group health care coverage, including insurance premiums and retirement. So that goes back to your answer before about health insurance premiums. Yes, seems to us to be a payroll cost. 401k match, yes, seems to us to be a payroll cost. Disability insurance and the like, life insurance doesn't seem to be a payroll cost, at least not the way that it's defined for purposes of the PPP loan. So you have to, it's not every amount that you make available to your employees would qualify as payroll that can be taken into account for purposes of determining how much your loan should be and how much should be forgiven. So you do have to slice and dice a little bit and just be careful about those distinctions.
So great. So this is an area obviously fraught with, this is why we really recommend to people that you consult with your advisors. This is a detailed analysis and one that you really want to be tracking as you're going through this 8-week period and trying to make decisions based on the best available information, which is not much. The acting director of the New Hampshire SBA has described the Paycheck Protection Program as the SBA trying to build a plane while it is flying. And that's a pretty accurate description. The SBA is just overwhelmed here. And if the program itself is a plane, the forgiveness is the landing gear. And they're just not focused on that yet. They're more focused on getting the money out the door and then turning to the loan forgiveness, which is just creating a tremendous amount of uncertainty for businesses trying to make decisions under this environment. So again, that's why we keep reiterating, focusing on the context of the loan, the purpose of the program itself, and not trying to be overly creative or gaming the system too much. There's just, and particularly again for defense contractors, a lot of risk involved in playing games with federal money. So if you are able to receive forgiveness, this is great news. The forgiven expenses don't have to be, when you spend the money in the right way and it gets forgiven, you don't have to repay the loan. And the CARES Act made it clear that the forgiven debt would not be treated as cancellation of indebtedness income, which is a tax concept. I won't get into that too much here, but that was generally good news. You weren't going to have to treat this as income, but rather it was just money that came in. The IRS has recently made it clear that the expenses that are paid using those forgiven loan proceeds, however, cannot be deducted. And that might make some sense that if it wasn't income when it came in, you can't deduct it when it goes out. But particularly for sub-S corporations and potentially and for partnerships, this can cause problems and mitigate some of the benefit, the tax benefit from the loan. So you'll want to talk to your accountant about exactly how that's going to play out for you, but that is something to give some consideration to. If the loan is not forgiven, quite frankly, that might not, this is why we suggest not spending the money in a manner that is different from how you would make your ordinary business decisions. If it's not forgiven, you have to pay it back. but it's a very, very historically favorable terms. Interest is at 1%. There is no payments due for the first 6 months, and then the loan has to be repaid in full in 2 years. So these are, in ordinary circumstances, if you weren't comparing paying the money back to basically a convertible grant, the loan terms are not bad. But you still, even if you're using the loan for not forgivable purposes, it has to be directed 75% to payroll costs. So that's we're expecting further clarification on that. So yes, it is possible that a portion of your loan will be forgiven and a portion will not be forgiven and will have to be paid back. So that's part of what you want to plan on this. There are a number of people who receive these funds and are, without getting into these details, are making assumptions that they don't have to pay the money back and making business decisions based on this idea of quote unquote free money. And that is potentially very dangerous given the lack of guidance on loan repayment that we have so far. So planning for forgiveness, keeping track over the 8-week period of what is available is important. So there's a question about whether the PPP loan for companies that act as employment agencies for contract labor, can they use the loan for contract employees? If you're, to the extent that that company is paying those workers directly and it otherwise is getting reimbursed from the companies that they work for, the actual employer, the person who is writing the paychecks, can use the loan proceeds for that. If you are the company that has hired independent contractors, or you have a staffing agency, your payments to that staffing agency, with some exceptions for personnel employment organizations that I won't get into here, those payments are not allowed. But if your business is, if these are your employees and you just sub them out to other people, yes, that should be allowed.
Yeah, so I think the question is about not that example, but the prior one, Helen, which is if you are looking to augment your staff and you hire a company to provide you with personnel, but they are not your employees, then essentially you're paying money out to an independent contracting company, and those payments out, even though they will be used to pay the people who are providing the work, are not a forgivable expense under the PPP. The
Yes.
PPP breaks it down how Helen was describing. So you can claim only your actual own W-2 employees and the amount that you pay them for payroll for purposes of PPP forgiveness.
Yes. All right. I think we're back to you, Matt.
Yeah. So just to wrap up the discussion on the PPP loan, as Helen was describing, any amount that's not forgiven, it's still not terrible, right? I mean, it has very good loan repayment terms. Repayment is deferred for 6 months, so you don't have to pay any amount back for 6 months. Full repayment's not due for 2 years, so it's a very favorable loan, and you can pay it back, prepay it whenever you want. So if you don't think you're going to need it, and let's say 75% of your PPP loan is forgiven and the other 25% is not, then that 25% that's not forgiven, you can either continue to carry on your books as additional loan proceeds to be paid back at a later date. It's not secured debt. It's very favorable, but it does need to be paid back. So if you don't need it, some of our clients are talking about just paying back the amount that they don't end up utilizing. One kind of side note, again, that Helen alluded to there is the danger you can run into in assuming that your PPP loan is 100% forgivable. You definitely should not assume that, right? The way that you calculated how much of your loan you could get is very different than how you calculate how much is forgivable. And I think you have to assume that it's very unlikely that 100% of your PPP loan would actually be forgiven. And if you then try to make payments out of the loan proceeds, let's say, for example, large bonuses to people that then turn out are not a forgivable expense, you have then paid that money out to your employees thinking that it was, kind of using the loan proceeds as kind of free money. And it turns out that it's not. You're then in the position of the money's out the door, you can never recoup it, but you also have to pay it back to the government as part of the PPP loan that is not forgiven. So that's why we're urging caution for a lot of our clients to make sure that they're only trying to get forgiven that portion of the loan that it really is consistent with the purpose of the PPP program and what they can clearly document. So let's talk about documentation a little bit. We've alluded to this a little bit, but just some tips. I mean, you really do need to keep detailed records. Hopefully you have a good sense of what is forgivable for payroll expenses, rent, mortgage interest, utilities. Keep very detailed records about how and when you made those payments to make sure that you're able to readily track how every dollar of the PPP loan that you want forgiven was expended. One tool for that would be to keep the PPP loan proceeds in a separate bank account. And what we've had some clients do is to draw on that account only PPP expenses that they think would be forgiven. So for example, you could pay your rent directly out of your PPP loan funds account. When payroll is due, calculate how much of the payroll that you have due would be a forgivable expense for your PPP loan proceeds. Transfer that amount out of your PPP loan account into your payroll account at the time you're making payroll. So you can then very clearly show that it wasn't your entire payroll that was paid using PPP loan proceeds, but only that portion of your payroll that would be forgivable under the parameters that apply to PPP loans. So, that kind of careful tracking and clear path, I think, will do a couple of things. It will help you with your application for forgiveness. And if a question does arise down the road, if there's an audit, will help you more readily defend the audit and show how the proceeds were paid. So how does the application work? Well, one thing to keep in mind is that you're actually going to be applying not to the SBA, but you're going to be applying to the bank from which you got your PPP loan. So you're going to, within 90 days after the end of your 8-week period, have all of your documentation ready and apply to your bank for the loan forgiveness. And they have 60 days from the day they get your application for forgiveness to render a decision about what portion or all of what you're providing in terms of documentation would result in loan forgiveness, right? So you do want to be careful with the documentation that you're providing and do what you can to carefully document how you've been spending the money. So I know there are a bunch of questions about sole proprietors and partnerships and what they need to show for their loan forgiveness. And some of it's not entirely clear. There is some guidance out there around sole proprietors, less about partnerships. Let's see. And Helen, I know that as you and I talked about it, there's some guidance about the Schedule C income guidelines. Maybe you can just jump in and address that versus the 1065 and partnership.
Sure. So there are rules for sole proprietors who have Schedule C income. And the SBA has said that for people with Schedule C income, they may only deduct or have forgiven the mortgage, utility, rent type payments if those were items that they paid on their it showed as being paid, that category of expenses being paid on their 2019 Schedule C. And they have also decided that they will forgive for Schedule C people 8/50 seconds of their Schedule C gross profit. So basically 8 weeks of what they made in 2019 will be forgiven for sole proprietors. For partnerships who report on a K-1 or Form 1065, they have said that they don't want those partners to treat themselves as self-employed individuals, because that would create confusion between who was supposed to apply. Were they supposed to apply personally, or were they supposed to apply through the partnership? So the SBA wants partnerships to apply for one loan as a partnership. And there are slightly different rules for partnerships versus the sole proprietor. So the sole proprietor is going to basically provide their 2019 Schedule C and proof that they both historically had one sort of set of expenses and the payments that they made. For partnerships, they're going to look at the payment to the partners on what the actual payroll records were, subject again to this $15,000 amount, which is $100,000 annualized, which I'll just quickly answer. This was on the seasonal employee question. This $100,000 annualized limit applies to everyone during this 8-week period. No more than the $15,380 something can be paid per person and be forgivable. That's a maximum cap. It doesn't matter that you ordinarily make more during a particular 8-week period and some periods less. This is a cap for everyone, and part of that gets to the that's just the limit. So partnerships, as compared to sole proprietors, would apply for loan forgiveness based on their actual payroll costs and not merely what they used to pay. And partnerships would also be able to presumably apply for forgiveness for rent, mortgage, interest, and other payments without regard to whether or not it was listed on their Schedule C. So there's a slight difference between the way partnerships and sole proprietors are treated. And for partners, for both partners and sole proprietorship, healthcare expenses for employees are allowed, but not for the owners. So that's another distinction between the owners of the business versus the employees.
So in terms of documentation, just in general, so thanks, Helen, on the specifics for solos and partnerships. In general, you will want to keep detailed records. Let's move to the next slide. So you want documentation regarding the number of full-time employee equivalents, how much you paid them for the 8 weeks, what their rate of pay was, and for prior periods to show that there was a consistency there. You can use your payroll tax filings to the IRS. You can use your filings with the state, and you just need to be able to verify the payroll that was paid during that 8-week period. With other expenses that can also be forgiven, you need to come up with documentation to show that you paid your mortgage interest, that you paid your rent, that you paid your utilities. And again, if you're paying all of that out of a separate account, it makes it a little easier to show. You can show them canceled checks, bank statements. You can show them documents, other documents that can verify the payments that have been made in terms of amount and timing. Remember, it's both. It has to be payments in that 8-week window. So it is important just to keep that in mind. You also have to provide, as part of it, a certification from a representative of the business that all of the documentation that you're providing is true and correct. The certification has to include a statement that the amount that is being requested for forgiveness was used for the purposes you see here on the slide, right, to retain employees and for other forgivable expenses that we've talked about, interest payments on uncovered mortgages, payments on rent, utility payments. And as an interesting or another category, I guess, other documentation that the SBA may determine is necessary. So there's obviously a little bit of a window there for there to be future requests from the SBA about what it will take to verify that the amount that you're asking be forgiven should actually qualify as being forgivable. One other note that's not on the slide, but a point I want to make is, remember, you're making this application for forgiveness not with the SBA, but you're making the application for forgiveness to your bank. So there may also be additional requirements that your bank may layer on top that they will want to see to verify that they feel comfortable approving the forgiveness loan request. Now, what's interesting is the banks themselves are entitled under the CARES Act to rely on the documentation that they get. They don't have to do a lot of, underwriting on the materials that you provide. But that aside, they may still ask for additional documentation so that they feel as though they're at least able to meet their minimum obligation of confirming the timing and the amounts that were spent for forgiveness purposes. So not sure how that might shape up, what other guidance may be provided to provide some more specificity around that. But you just want to keep that in mind too. That's why the careful record keeping is so important. So we just wanted to make sure that there are certain takeaways, keeping in mind, by the way, we understand there may be some other questions here that we'll try to address. I know there was one actually I meant to address about the banks. The question had come in about whether banks can treat different requests for forgiveness differently. And I guess there's nothing that I've seen that says they can't, but just in general, banks, I think, will be very leery about doing that because they're not going to want to be accused of discriminating against one type of borrower or another as they're determining whether or not an application for forgiveness should be granted. My guess is they're going to try to be as consistent as they can and generally probably look at those applications with somewhat of a light touch because they feel as though they're going to be entitled to rely on the documentation as presented. So they'll probably add up some numbers and things, try to confirm that the documentation that they got is authentic. But much beyond that, my guess would be they're not going to do too much. But I do think they're going to want to have one set of rules that generally applies to how they will oversee that review process so that they're not put in a position of being accused of treating different lenders differently. So the takeaways that we wanted to make sure that you're aware of, again, it's just going back to a lot of what we talked about, right? The guiding principles, act reasonably, take into account the purposes of the program. Generally don't push the envelope, right? I don't think there's anything really to be gained. The worst case scenario is that it's a loan that you have to repay at 1%. And if you are ever accused of misusing the loan proceeds, then not only do you have to pay the loan proceeds back, but if it was more egregious, you could be accused of some crime like fraud in the way that you applied for the forgiveness. That obviously takes a higher level of intent, but you want to be careful that you're not stepping over the bounds and why kind of open yourself up for that just to try to gain some more dollars on the forgiveness side. So I think we just think it makes sense to be cautious in how you're applying for loan forgiveness and apply only for those amounts that you're able to readily justify. Second, keep your eyes and ears open for updates. Updates are fast and furious. As Helen pointed out, the SBA is kind of building an airplane while it's in flight. So there are consistent updates on a variety of different topics without rhyme or reason in terms of timing or what topic they will address. So just be aware that those updates will probably continue to come out. So either check in on those updates periodically or ask your advisors to keep you up to date in terms of what advice is being provided. I've already said this, keep careful records and don't get too creative with how you're approaching the forgiveness. So I think with that, those are the things that we wanted you to take away. There are some other questions that have come in. One about whether we're going to find out and when we might find out whether the 8-week period is going to be extended to 10 or 12 weeks. Boy, that's a good question. Maybe never, maybe after the 8-week period is over, maybe before. They don't provide any guidance about when particular guidance is coming out. And I think that what we have found is that when there's an issue that either is clearly not addressed or has not been addressed before, or that's politically hot, like big companies taking PPP loans out, those are the ones that then tend to then generate the updates. The 8-week period, though, was built into the statute. So unless the SBA wants to be, aggressive in its interpretation, or Congress acts to extend the time period, again, I think you've got to assume that we're stuck with the 8-week period, at least until we get a clear indication through additional guidance or a change to the law that that period will be extended beyond the 8 weeks. So other questions, are guaranteed payments made in the normal course considered payroll as long as they're under the $100,000 threshold? So again, with LLCs, I assume, they can be either a flow-through entity, a disregarded entity like a sole proprietorship, or it can be treated more like a partnership. And I think that Helen's comments before about how partnerships would be treated from a tax perspective would also apply to LLCs. But Helen, I don't know if you have additional feedback there.
So that's the Treasury's questions and answers on this specify sort of by tax treatment. Are you a sole proprietorship? Are you a partnership? Are you an S corp? And have guidance for, this was for the loan application itself, but for how those entities were treated, and said that for LLCs, the answer is, what's your tax treatment? So being an LLC doesn't affect the treatment. It's whether if you're an LLC with a sole proprietor, it's a disregarded entity, then it's going to be based on 8/52 of your 2019 income. If the LLC is treated like a partnership, then it's going to be the payroll costs that were paid during that 8-week period. And if there were guaranteed payments made subject to that threshold during that 8-week period, then that should be considered payroll.
Yeah, and I take it with the question about guaranteed payments, that is an entity that's taxed like a partnership. So again, you would look at it through the eyes of how would a partnership or an entity taxed as a partnership have to justify its payroll costs. Let's see. So the question was, if you can't repay the loan in 18 months, right? So it is a loan that's payable. Let's say you get a $100,000 loan. Hopefully, a large chunk of that, let's say 75%, to make up a number, would be forgiven, right? So you get a $100,000 loan, $75,000 of which is forgiven, the other $25,000 of which is not. That $25,000 then turns into a loan that is due 2 years after the loan was dispersed. It accrues interest at 1%. No payments at all are due for the first 6 months, but then payments do become due. And again, it's a loan that you have with your bank, right? So looking forward, I would think that loan would be treated like any other loan by your bank. Again, it's not a secured loan, meaning there's no lien on your company's assets. There are no personal guarantees. So it will be, in terms of priority, well behind the other loans that you may have with your bank. But it is one that would continue to be an outstanding loan obligation until paid off. Now, your bank may not push as hard on that loan as it might on others, because it's, as I understand it, they're going to be 100% guaranteed by the SBA. So if there is not repayment, the SBA may pay the bank the $25,000. The bank may then write off the loan, and you would then be in a position as a company recipient of having $25,000 of cancellation of indebtedness income potentially. And the IRS may treat you as if you got $25,000 because it's money you had owed and you no longer owe. So there could be a tax implication to you as well. It would depend on the circumstances and how that was addressed at the time. But just think of it as a regular loan. Fortunately, no lien on the assets, no personal guarantees, generous loan terms, but a relatively short repayment ramp when you only have 2 years from the time you took the loan.
So, and just to jump in, the CARES Act itself said that the repayment period could have been up to 4 years. And the SBA decided, because at the time they thought that the economy was that particularly based on this program, would have this 8-week sort of shutdown period, would have 8 weeks of people being in the Paycheck Protection Program, and the economy was just going to start right back up in June. And there would be no problem for companies repaying this loan within 2 years. When the SBA picked this 2-year period, it was based on an idea that companies would not be struggling. If they got this loan, they wouldn't be struggling. And I think we're starting to see that shutting the economy off was a lot, quote unquote, easier than turning it back on. And that there is not necessarily going to be, no impact to companies starting in June. So and this is an area that the SBA could, on its own, make a decision without having to go back to Congress and have the CARES Act amended. It's possible that they could decide to extend the repayment terms without going back to Congress. So there's some chance that could, if depending on how the economy turns out, there's some prospect that might be changed. That would be a change, and there's no indication that they're going to do that. But that would be an easier fix than fixing the 8-week period to make the 8-week period 10 or 12 weeks. I don't think the SBA can do that, or Treasury on their own. They might be able to make an argument, but it would be easier for them to change the repayment terms than the 8-week period.
So, and it also just highlights the need to make sure you're careful on the forgiveness and you don't end up with a bigger loan than you intend, right? So if you want to be careful about how you're using all of the proceeds, make sure you're at least using them for permitted purposes, right? Because you want to make sure that you're at least using the loan. You can use it after the 8-week period, but you can only use it for permitted purposes after the 8-week period, right? So you can't use it to pay other debt. You can't use it to go on vacation, but you can use it for permitted purposes. It just may not be forgiven. So be careful about how you calculate the forgiveness portion, so that you can just make sure that you're able to plan as best you can how to address it. And I think with that, we're well past our time. I don't want to keep people on the line here who may have actual work that they need to go do. Happy to stick around and continue to answer a couple of questions. Thank you all for the opportunity to speak with you about this. I hope we were able to answer some questions. I know it's a very uncertain kind of regulatory framework. Keep in mind the context, keep in mind the purpose, keep in mind the need to keep careful track of how you're utilizing the proceeds. Just don't be too, for lack of a better word, greedy about the forgiveness piece, and essentially treat the forgiveness amount as you would as if it wasn't going to be forgiven, and be a good steward of the loan proceeds. And I think that at the end of the day will be the way you'll come out in the best possible position. So thank you very much, everybody.
Thank you, guys.
Thank you, Matt and Helen, for all the information and helpful tips. For those that want the video and the presentation, send me an email and I'll send them out to you, but they will also be posted right on our NHADEC website. So thank you again for attending, and thank you, Matt and Helen.
Okay.